Well, good morning and welcome everyone joining us today, both here in person at Arundel House and following these proceedings virtually. The work of the Lampard inquiry continues at pace. Much of this work occurs between public hearings and out of public view, and counsel to the inquiry, Nicholas Griffin KC, will provide an update on the progress of the inquiry's work during his opening statement later this morning. I wish to take this opportunity today to speak further about my role in conducting this inquiry. The Lampard inquiry is governed by the Inquiries Act 2005 and the Inquiries Rules 2006. This legal framework is intentionally flexible to allow for chairs of all public inquiries to run their inquiries in the best way possible to meet their unique subject matter, scope, and terms of reference. I, as chair, have wide discretion as to how the Lampard inquiry will operate. Our inquiry is different from other public inquiries. Our subject matter is distinctive, ours being the first UK public inquiry into mental health care, and we're investigating a wide range of issues over a long period of 24 years. The differences in scope between public inquiries mean that, on occasion, I may not adopt the same approach as others. At times, the Lampard inquiry will do things differently to other public inquiries, and this should be seen as a strength in our process and not as a failure. It means that I have chosen, with care and consideration, a particular approach because I believe it to be the best and most effective way to meet my duties under the Inquiries Act 2005 and the terms of reference for this inquiry. This inquiry will be investigating the death of mental health inpatients in Essex between 2000 and 2023. The core purpose of this inquiry is to find out what happened, to undertake a thorough investigation of the systemic issues and failings. After this investigation, I will publish a report outlining the key facts, evidence, and my analysis, along with my findings and my recommendations for impactful change. I'm focused on this inquiry leaving a positive legacy of change for mental health inpatients. This inquiry is here to understand what happened in Essex so that I can make recommendations to help ensure that the same failings do not happen again. I remain mindful of the developments occurring within mental health inpatient care within the NHS more widely and within government. Just last week, on the 3rd of July, the government published its 10-year health plan, which sets out the government's vision for healthcare over the next decade, which includes planned changes that will inevitably impact mental health inpatient care and oversight. I will ensure that at the time that I make my recommendations, those recommendations are applicable to the most current systems, structures, and setup, so that the changes I recommend are as implementable and impactful as they can be. As chair, I act independently. Because public inquiries are inquisitorial rather than adversarial, there are no sides for me to take in this inquiry process. As chair, I must consider the views from the whole spectrum of core participants and interested parties. The inquiry's independence is not only from government and those that are the subject of this inquiry, but also from all participants. I must and I will consider and treat all interested parties fairly. They must all have a voice in these proceedings. I cannot favour or promote the interests of any one party or participant or group of participants over another. As chair, I must be fair, independent, and transparent in my actions. I give careful consideration to the views of core participants on how the inquiry is to be conducted, and I'm grateful for the submissions which were provided to me following the April hearing. I've directed my team to take forward certain matters raised in those submissions. Understandably, some core participants have firm views on their preferred way for the inquiry to be run. I do not seek or wish to cause frustration or distress for participants by the way in which this inquiry is conducted. But differences in opinions and expectations may make it impossible for me to satisfy everyone participating in this inquiry at all times. Furthermore, the Inquiries Act and the Inquiries Rules do set out certain requirements for the conduct of an inquiry. In particular, it's a requirement that in making any decision as to the procedure or conduct of this inquiry, I, as the chair, must act with fairness and with regard also to the need to avoid any unnecessary cost. For these reasons, the decisions I make on the conduct of the inquiry may not always align with the views expressed by participants. This should not be seen as a dismissal of those views, which I will have given careful thought to, but it's a reflection of my wider duties and considerations as chair. I will, of course, keep the inquiry's processes under review, and I will listen to the submissions of its core participants and those engaging with it. That includes the matters raised in submissions provided after the inquiry's last hearing, about which Mr. Griffin will say more in his opening statement. Ultimately, the decisions on how to conduct this inquiry are mine and mine alone. I feel the heavy weight of this responsibility, but I have always and will always continue to make decisions that I truly believe to be in the best, most efficient and effective way for this inquiry to fulfil its terms of reference and to enable me to make recommendations for long-lasting and impactful improvements to the care of mental health inpatients. To end, I shall say a brief word about the duty of candour. In order for this inquiry to fully understand what happened, why it happened, and to make meaningful recommendations for change, we need those responding to our requests for information and asked by us to give evidence to do so with complete candour. Candour is not about responding to the inquiry's requests with the minimum effort possible. It's not about waiting until being pushed and chased by this inquiry before sharing all the relevant information or documents. Candour is about admitting where things went wrong. It's about open and honest sharing so that the inquiry can learn the lessons that will improve mental health care. It's about putting the public interest first over and above personal reputations and organisational interests. Those asked to provide evidence owe it to this inquiry, to the public, and most of all to the bereaved families, to be fully transparent, even if doing so is to the detriment of themselves or their organisations. I say it again, and I will continue to say it throughout this inquiry. I will accept nothing less than full candour. Thank you. I'll now hand over to counsel to the inquiry, Nicholas Griffin, Casey.
Thank you, Chair. This is the Lampard inquiry's fourth public hearing. In September and November last year, the inquiry heard powerful and deeply moving commemorative evidence from the families and friends of those who died whilst receiving mental health care from trusts in Essex. In April and May this year, the inquiry heard its first tranche of evidence relating directly to its terms of reference. Given the stage that the inquiry had reached, and in light of the substantial volume of material that had been received just prior to the hearing, the April hearing was introductory in nature, setting out background and contextual matters. The inquiry heard some very important and thought-provoking evidence, from which there emerged common themes and clear lines of inquiry. In this hearing, however, the inquiry will hear evidence of a different kind. Over the course of the next week or so, the inquiry will focus solely on hearing evidence from some of the bereaved family members concerning the deaths of individuals under the care of the South Essex Partnership University NHS Foundation Trust, or SEPT, North Essex Partnership University NHS Foundation Trust, or NEPT, and Essex Partnership University NHS Foundation Trust, or EPUT. This hearing provides a crucial opportunity for the inquiry to hear from those at the heart of its work, the families who have been directly impacted by these deaths. The evidence shared during this hearing will also help to guide the inquiry's work and to ensure that families' concerns, experiences, and unique insights are at the core of the inquiry's investigations. The evidence received and heard will form a key part of the inquiry's ongoing investigative process into those deaths. We are extremely grateful to all of those who have provided witness statements for this hearing and for their courage in sharing the traumatic details surrounding their family member's death. In both this opening statement and throughout the next week, the inquiry will be referring to and hearing about matters that will be distressing and difficult. We will be hearing disturbing evidence about individual deaths and experiences. The details may be deeply painful, as they will also resonate with the trauma, grief and loss suffered by many of those who are here today or watching online. Indeed, after this opening statement, we will be hearing from Ben Jackson and Adam Rowe about their and their families' experiences in connection with the deaths of Ben's brother Ed and Adam's mother Mandy. At the start of each day and evidence session, we will briefly summarise the evidence that will be heard in order to give those attending, watching and listening the opportunity to decide whether or not they wish to, or indeed are able to, engage with that evidence. The timetable for this hearing is also available on the inquiry website. As I've said, people attending or watching remotely may find some of the matters I'm going to talk about and that we hear evidence about distressing. Before I go any further, I would like to make clear that emotional support is available for all of those who require it. The well-being of those participating in the inquiry is extremely important to the inquiry. I would like to be clear that anyone in this hearing room is welcome to leave at any point. We have 2 support staff from Hestia, an experienced provider of emotional support, here today and for each of this day of this hearing. And there's a private room where you can talk to Hestia support staff if you require emotional support at all times throughout this hearing. The Hestia support staff are wearing orange lanyards and orange scarves and raising their hands. Or if you want to, you could speak to a member of the inquiry team and we can put you in touch with them We are wearing purple-coloured lanyards. If you're watching online, information about available emotional support can be found on the Lampard Inquiry website at lampardinquiry.org.uk and under the Support tab near the top right-hand corner. We want all those engaging with the inquiry to feel safe and supported. The role and remit of the inquiry is to investigate mental health inpatient deaths. It's not the role of the inquiry to intervene in clinical decisions for current patients or to act as a regulator or in the role of the police. However, the inquiry has a safeguarding policy and takes safeguarding matters seriously. Where we receive any information which meets our safeguarding threshold, we will pass it on to the appropriate organisation. This is something which has been done since the inquiry was established and which we'll continue to do. I, Chair, am assisted at this hearing by members of the Counsel to the Inquiry team, Rachel Troop, Kirsty Lee and Kian Pucks. They've been working very closely and directly with bereaved families and, where applicable, their legal representatives, particularly in advance of this hearing. As I have mentioned previously, the Council team also works closely with the Lampard Inquiry Solicitor team under Catherine Turtle. We also work closely with the Secretariat team and the Inquiry's engagement team, who are part of the Secretariat and with whom many of those engaging with the inquiry have been in contact. I want to be clear that my Counsel to the Inquiry colleagues and I have been instructed by you, Chair, to assist you in your important task. We are part of the inquiry team working for you. As you have explained during the course of your opening statement, we are independent from all other organisations and individuals involved in this inquiry, and we must be very careful to ensure that we remain so. I would also like, once again, to introduce the lawyers who are representing core participants. Representing first bereaved families and those with lived experience. Bates Wells, with their instructed counsel Sophie Lucas. Bat Murphy, with their instructed counsel Fiona Murphy, King's Counsel, and Sophie Miles. Bindmans, with their instructed counsel Brenda Campbell, King's Counsel, and Tom Stote. Dayton Pierce Glynn. Hodge Jones Allen, with their instructed counsel Stephen Snowden, King's Counsel, and Elena Mishra, King's Counsel, Dr. A.K. Burren, Rebecca Henshaw-Keane, and Jake Looms. Erwin Mitchell, with their instructed counsel Maya Sikand, King's Counsel, and Laura Profumo, and Lee Day, with their instructed counsel Maya Sikand again, Tom Stote, and Laura Profumo. And representing the organisations, Bat Murphy for Inquest, with their instructed counsel Anna Morris, King's Counsel, and Lily Lewis. Brown Jacobson for EPUT, with their instructed counsel Eleanor Gray, King's Counsel, and Adam Fullwood. Kennedy's for Nelft, with their instructed counsel Valerie Charbet. In-house representation and DAC Beechcroft for NHS England, with their instructed counsel Jason Beer, King's Counsel, and Amy Clark. The Government Legal Department for the Department of Health and Social Care, with their instructed counsel Anne Studd, King's Counsel, and Robert Cohen. Mills and Reeve for the Integrated Care Boards, with counsel Kate Brunner, King's Counsel. Jenny Richards, KC, and Rachel Sullivan for the Care Quality Commission, and Bevan Britton for OxyHealth, with Fiona Scolding, King's Counsel. I would like to take the opportunity in giving this opening statement to cover the following areas. Firstly, I will report on progress made by the inquiry since our last hearing in April and May, particularly the work that is taking place outside the context of our hearings, And secondly, I will turn to the very important evidence that you'll be hearing over the next week. Starting then with the progress of the inquiry. Your team continues to progress work in a variety of areas, much of which will take place outside our hearings. We are undertaking specific and targeted further work following the April hearing, examples of which I'll come on to in a moment. Chair, following the April hearing, you invited core participants to provide written comments on pertinent issues and matters that arose during that hearing. A number of core participant legal teams took you up on that offer, between them representing many individual core participants. The inquiry's legal team has been working through all the submissions sent in and considering each and every one of the actions proposed, as have you, Chair. The actions included, amongst other matters, possible lines of inquiry and investigation, potential sources of evidence, and proposals for how the inquiry should be run. The inquiry was very pleased to receive a number of helpful and persuasive proposals from core participants' legal teams, including those representing bereaved families and those with lived experience, as well as the providers. Some of the actions proposed, particularly the more straightforward ones, have already been actioned or are in the process of being actioned. Others are under active consideration, and as part of that, I have invited the council teams who provided submissions to meetings with me to discuss those submissions. Some of those meetings have already taken place, and they will continue into this month and a little beyond. I welcome this dialogue. I will report back in relation to principal points raised once those discussions have concluded. The meetings to date have proved positive and helpful. I also intend to invite the teams of core participants who did not provide submissions at the end of the last hearing to meet with me. Core participants who do not have legal representation form an important part of those engaging with the inquiry. We will, of course, be hearing the evidence of several this week. The inquiry will be in touch with them after this hearing to offer meetings to discuss the ways in which the inquiry is operating. Finally, on this point, Chair, the inquiry team will also now run a series of in-person drop-in sessions in Essex. This will be an opportunity for those engaging with the inquiry to meet with the inquiry team and to ask any questions or raise any concerns which they may have face-to-face. Work following the April hearing. Chair, by way of update, the areas for more detailed investigation identified by the inquiry team and suggested by core participants following the April hearing include, but I should stress are not limited to, investigations and information collated by regulatory bodies, for example, the Health Services Safety Investigations Body, Local Government and Social Care Ombudsman, and Patient Safety Commissioner. The regulatory landscape more broadly, particularly when there are systemic issues and failures at play. Further information on the role, remit, activities of the Care Quality Commission during the relevant period. Further information in respect of the health and safety executive prosecutions of EPUT and its predecessor trusts, and any correlation with the CQC's position and responsibilities at the relevant time. Notification, monitoring, and oversight of patient safety concerns more widely. A variety of specific topics and issues arising from EPUT disclosure and the evidence of Dr. Milind Karale. Examples include policies and documentation, evaluation and monitoring, governance, risk assessment, the use of the electronic patient record, neurodiversity and autism, screening of referrals, challenges or limitations related to assessments, psychiatric medication, versus psychological therapy, coercive and restrictive practices, the care plan, the care programme approach, the community mental health framework, and specialist units. Next, further questions following the additional evidence of Eput's Zephan Trent relating to the use of Oxyvision, the culture of care programme and the issue of race equality, issues relating to the care of neurodiverse patients more widely, further examination of the duty of candour, the death certification process, and the quality and availability of data about deaths in mental health detention. The inquiry continues to engage proactively with relevant organisations and individuals to secure further evidence in these areas. Rule 9 requests for disclosure have been sent out by the inquiry since the last hearing, and we are in the process of formulating and sending out further such requests. This is to ensure that the various matters arising from the last hearing are thoroughly and robustly followed up. The inquiry continues also to progress its work in many other areas, from actively exploring issues of physical and sexual safety and engaging with Essex Police, with whom the inquiry has in place a memorandum of understanding, through to its investigation of private providers. I would like to say a few words now about one of the other healthcare providers the inquiry is looking closely at, the North East London NHS Foundation Trust, also known as NELFT. In addition to providing extensive mental health services for people living in various London boroughs, NELFT provides mental health services for people living in Essex and did so throughout the period with which the inquiry is concerned. Notably, NELFT currently provides children and adolescent mental health services, or CAMS, to young people in Essex. Dealing first with the criminal trial. Those following and engaging with the inquiry will have noted that despite being a relevant and significant NHS provider of mental health services, NELFT did not feature in the inquiry's April hearing. It had originally been intended that NELFT evidence and witnesses from NELFT would form part of the April hearing. At the beginning of April, however, you decided, Chair, to remove NELFT evidence from the hearing. That was because a long-running criminal trial, in which NELFT was one defendant and a previous NELFT employee, a ward manager, was another, had reached a sensitive stage at the Central Criminal Court. Its jury was about to be sent out by the trial judge to consider its verdicts. When you made that decision, the inquiry had been made aware that it was possible the jury would still be deliberating throughout the time of the inquiry's April hearing and beyond. That turned out to be the case. And in fact, the jury in that criminal trial did not return verdicts until early June of this year. Whilst in many circumstances a public inquiry and criminal investigation or trial can continue alongside each other, Chair, you were concerned that adverse comments about NELFT made in public at the April hearing could have had the potential to prejudice the criminal trial at that particularly sensitive time. You therefore instructed the inquiry to act accordingly. In the event, NELFT was acquitted of an offence of corporate manslaughter, and the ward manager was acquitted of gross negligence manslaughter. But both NELFT and the ward manager were found guilty of breaching the duty created by Section 3 of the Health and Safety at Work Act 1974, in that they failed to ensure others were not exposed to risks to their health and safety. These criminal offences related to the self-inflicted death of an inpatient at one of its hospitals in the London borough of Redbridge in July 2015. In short, Nelft had failed to remove known risks to the inpatient, who was able then to take her own life. Moving to Nelft disclosure. Quite separately, a significant amount of material requested from Nelft was provided to the inquiry too late to form part of the bundle put together for the April hearing. The inquiry also requested a position statement from Nelft, which was returned after the extended deadline. Given the volume of material received so late in the day, it was not possible properly to review and include it in the bundle for the April hearing. The evidence from Nelft will therefore form part of a future hearing, at which we will also require Nelft's CEO to attend and to address you. Moving on to a new topic. The inquiry has been working hard to ensure disclosure is made to court participants and witnesses in a timely and efficient way. Up until now, disclosure of large volumes of material and of hearing bundles has taken place by way of upload to the inquiry's evidence portal, Exchange. The inquiry has looked carefully at how best to assist court participants in their review of the documentation disclosed by the inquiry, and it has also taken on board the representations and views of the court participants as how they might best be assisted. As a result, the inquiry will now extend the use of the relativity platform to all court participants, material providers, and their legal representatives. This will also improve the material provider review process. Relativity is a disclosure platform that facilitates efficient review and analysis of documents. The inquiry intends to secure access to relativity for all court participants no later than August, at which time all material already disclosed will be accessible on that platform. Any future disclosure will then be made via relativity, including material relevant to the October hearing and the material for future hearings in 2026. Once relativity is up and running for court participants, the inquiry does not intend to provide material through any other means, unless, of course, there are circumstances where reasonable adjustments are required. From August onwards, therefore, all disclosure will take place via relativity, save in the case of unrepresented court participants with whom the inquiry will be in touch individually to put into place suitable and workable arrangements. The inquiry will ensure the effective deployment of relativity by issuing detailed user guidance, providing scheduled training sessions, and offering technical support. At the same time as relativity becomes available to court participants, the inquiry will provide its disclosure plan. This plan will set out the inquiry's proposals for the disclosure of evidence for its hearings, along with the proposals for disclosure of material not connected to those hearings. The plan will be provided with a timetable as to when disclosure of witness statements and other materials relevant to the terms of reference is likely to take place. This will allow court participants to plan their work and resources in advance. I'd like now to address the list of deceased. Chair, the inquiry continues to prioritise its efforts to compile, as best it can, a definitive list of deaths that fall into its scope. At the April hearing, you set out a revised approach to two of the particulars listed under your definition of inpatient death. In particular, you clarified the entry at G of your explanatory note that accompanied the terms of reference in relation to deaths following a mental health assessment. An amended version of the explanatory note was circulated on the 10th of April this year. I addressed it in some detail at the start of the last hearing. Since that revised approach was announced, the inquiry has sent further requests to the relevant care providers, requiring them to revisit the information that they hold and provide the inquiry with revised details of those who died whilst under their care. The inquiry understands that for some providers, that's going to involve adopting a broader approach to the disclosure of information and may take some time. The inquiry will provide further updates on this important work as soon as it's able to do so. It will be clear, therefore, that we still do not yet have a definitive figure for the number of deaths that come within the scope of this inquiry. The inquiry is acutely aware that this number is of particular interest. As you stated in September last year, Chair, the inquiry recognises that it may never be possible to provide with confidence a final or definitive number of those who died in the relevant period whilst under the care of trusts in Essex. The inquiry considers, however, that it owes a responsibility to those who died and to their loved ones, including those who are not core participants, to finalise the list of deceased to the very best of its ability. We will provide the most accurate number that we can when we have, with expert assistance, collected the data we need and analysed it appropriately. It's not just the number of deaths in scope that's important, although that is very important. The information obtained about those deaths is also required to enable reliable and robust findings to be made about the themes and patterns revealed by the data. Chair, I would also like to make clear at this stage that until the inquiry receives updated information relating to those whose deaths fall into the scope of the inquiry, we are simply not in a position to say how many of those involved serious failings or issues of concern, or were deaths that could have been avoided. The inquiry will continue to do all that it can to provide clarity in this area. We are determined to get the most accurate figure available using all of the information and expertise available to us. I am talking here about statistics. As I've said before, as an investigative process, we do have to look at information obtained in an analytical and objective way to see trends, to spot issues, and to make findings. But we recognise that behind the figures, each death was of a person with their own life and individual circumstances. One of the important reasons for obtaining the best information available in relation to the inquiry's list of deceased is to inform the work of Professor Donnelly, the inquiry's expert statistician, and her team. They have continued their work analysing the list of deceased and in helping to identify trends and matters of statistical significance to further inform the inquiry's work. Although it has been possible to prepare an initial analysis, there remains important work to be done before that output can be of assistance to the inquiry and can be shared with core participants. The key strands of their further work include the following. Firstly, as already outlined, obtaining the best available evidence to ensure that the list of deceased is accurate and that where possible, that it is triangulated against other available data, such as records of inquest. Secondly, obtaining denominator data. It is recognised that the list of deceased, even when complete, will represent only part of the picture. To draw meaningful conclusions about patterns, risks, and potential systemic issues, it will also be necessary to obtain information about the population of patients who were admitted to the same wards during the same period. This data, known as denominator data, is being sought, but there are challenges in obtaining it. Following this hearing, we intend to provide core participants with an interim report from Professor Donnelly, setting out in outline her approach and work to date. Although this will not represent any final analysis, we aim to share this to help inform further discussions at the data discussion, which I will now come to. Chair, you will recall during the April hearing that the inquiry heard interesting and helpful oral submissions from core participants touching upon the topic of data, along with constructive suggestions from counsel such as Fiona Murphy, King's Counsel, Brenda Campbell, King's Counsel, and Stephen Snowden, King's Counsel, on behalf of a number of the core participants, as to how the inquiry might approach the questions of data and data analysis in various different areas. Certain of those submissions were echoed within the written representations provided at the conclusion of the April hearing. This is an area in which the inquiry is particularly keen to hear further views from the core participants and is currently considering the most efficient way to facilitate the sharing of those views. To this end, the inquiry intends to host a data discussion involving the inquiry and core participant representatives. This may take the form of a chaired roundtable discussion to allow constructive suggestions as to avenues the inquiry may wish to explore. Further detail about the data discussion will be provided as soon as possible following this hearing. The inquiry has received and is considering submissions from core participants in respect of expert evidence heard at the April hearings. A number of points raised require careful contemplation moving forward. Core participant proposals include an expert instruction protocol and additional ways in which core participants may contribute prior to the instruction of an expert. Chair, you have firmly in mind the need for further expert evidence. We are actively considering other areas and other potential experts. We have, for example, already identified the need to obtain further expert evidence in respect of autism and neurodiversity. The inquiry is currently finalising the investigation strategy by which it will examine the circumstances of those who died on mental health inpatient wards in Essex. This is one of the matters I have been discussing and will continue to discuss with core participant counsel. Further detail about the inquiry's investigation strategy will then be provided to core participants. As part of its investigation work, the inquiry will liaise with the families and friends of those who have died, together with their legal representatives, about the matters which are of key importance or concern to them. The inquiry will ensure that they are kept updated of its work. Chair, you have chosen to receive witness statements and hear first from the families and friends. The evidence they give and the concerns they raise will provide the foundation for and will inform the inquiry's investigations. Chair, we have reached a stage where it may be convenient to take a break. May I therefore suggest that we break now and reconvene at 11:05.
Thank you. Mr. Griffith.
Chair, we've had a slightly longer break than we were hoping because the transcript has ceased functioning. This is what we propose to do. I'm going to continue with my opening statement. A written and hyperlinked version of it will go on the website as soon as possible, and if anyone feels they need it even more quickly, they can contact me and I can email it to them. In the interim, we hope that the transcript functionality can be reinstated by the time of our first witness, but we will reconsider the situation over the break following this opening. My apologies to those affected by the loss of the transcript. So, continuing my opening, and I'd like now to talk about staff evidence. The inquiry's investigation strategy will also influence and inform the evidence the inquiry seeks to obtain from staff members who worked for the healthcare providers during the relevant period. It has been well reported that in its non-statutory phase, the Essex Mental Health Independent Inquiry failed to secure meaningful engagement from staff who'd worked for the relevant trusts and private providers. It was one of the most influential factors in securing the statutory inquiry. This inquiry remains disappointed with the level of staff engagement. We are very grateful to those who have come forward and provided relevant evidence with openness and candour. They are few in number, however. The inquiry's investigation strategy will now allow it to take a targeted and focused approach to obtaining staff evidence. The inquiry's investigations, which will begin with the first-hand account provided by the bereaved family, will identify the key figures involved in providing care and treatment to the deceased, both on a ward level and those in positions of management. The inquiry will determine which staff are best placed to provide evidence that assists its work, particularly when looking at systemic issues. The inquiry will also continue to seek staff cooperation more broadly. You will recall, Chair, that in April the inquiry heard evidence of a culture of fear amongst staff working in NHS settings, a fear on the part of staff to speak up at the time they were aware of concerns, and a fear on the part of staff to speak up later when the matters were being investigated. Sir Rob Behrens told the inquiry that he had dozens of clinicians get in touch with him, indicating that they wanted to raise issues, but they feared they would lose their jobs and careers. The inquiry continues to encourage any person who has information that may assist the inquiry to come forward and provide that information, particularly those who worked within NHS trusts in Essex or for relevant healthcare providers. Chair, you have ensured the inquiry has in place a whistleblowing protocol to provide whatever protection it can for those individuals. You are seeking the views of the core participants as to whether providers and regulators should be asked again to give narrow undertakings in order to facilitate the flow of full and frank disclosure to the inquiry. I referred at the start of the last hearing to those undertakings. Following that hearing, the inquiry has amended the proposed undertakings in order to make absolutely clear that their intended purpose, what their intended purpose is, and their narrow remit. They seek to safeguard the interests of those who would like to raise issues. They relate only to the provision of material to the inquiry and would not enable any individual to avoid accountability for serious misconduct. Those amended proposed undertakings will be provided to all core participants following this hearing, so they have a better idea of what the inquiry is requesting. Core participants will be invited to provide views in writing in the first instance. the inquiry has been invited by one of the corporate core participants to consider organising a combined discussion with various providers and regulators to discuss the undertakings you are seeking. Chair, whilst your team proactively engaged with providers and regulators last year on this precise topic, the inquiry remains amenable to any joint and concerted effort which might assist in the furtherance of its work. I would like to turn now to say a few words about the Oxyvision evidence. During the April hearing, the inquiry was due to hear evidence about Oxyvision, a technology that uses infrared sensitive cameras to monitor patients' vital signs, such as pulse and breathing rate, in mental health settings. Chair, you took the decision to postpone the corporate part of that evidence on the inquiry's receipt, very late in the day, of a new witness statement from EPERT, which set out a material change in their approach to Oxyvision. In the interests of fairness, and to give all interested core participants and the inquiry time to review the new evidence, you determined that the evidence from EPERT and OxyHealth should be heard at a later hearing. On the 14th of May this year, the inquiry did, however, hold a pre-recorded evidence session with Hat Porter, a representative of the campaign group Stop Oxyvision. As you made clear at the time, Chair, the use of Oxyvision remains a matter of significant interest to the inquiry. We are acutely aware that it is also a matter of particular concern for a number of the inquiry's core participants. And I can say now that the inquiry intends to hear the delayed Oxyvision evidence at the start of the October hearing. At the outset of the April hearing, Chair, I outlined how you had directed that a Lampard inquiry recommendations forum should be set up, and that it's now referred to as the Lampard Inquiry Recommendations and Implementation Forum. This is to reflect the importance not only of the making of recommendations, but also the fact they need to be accepted and implemented. All core participants will be able to engage with the forum. We also announced in April that the inquiry has secured the assistance of a noted academic with expertise in public inquiries for the forum, Dr. Emma Ireton. Dr. Ireton will provide a paper this autumn, which will be circulated to its core participants. Its purpose will be to provide a contextual briefing on the framing, implementation, and monitoring of inquiry recommendations. In broad terms, it will cover the purpose and construction of recommendations, implementation and monitoring, relevant recent developments and current themes in inquiry practice, and a summary of recent inquiry approaches to implementation and monitoring. The Ireton paper will be provided to core participants along with a paper from the counsel to the inquiry team, which includes our suggestions for how the forum should work. We will then seek the views of core participants and other key stakeholders about the best way forward for the forum. May I also remind those following and engaging with the inquiry that it has in place various protocols. This is with the aim of assisting those who wish to engage with the inquiry in providing the best possible evidence in a way that also ensures they are supported throughout the process. All documents are kept under review. They include protocols on restriction orders, redaction, anonymity and special measures, on vulnerable witnesses, on witness statements, and principles of engagement for the July hearing. Chair, you have a wide discretion to put in place measures to support witnesses giving evidence. We will continue to work with witnesses and, where they have them, their legal representatives, to take an individualised approach as far as is reasonably possible. The inquiry also offers emotional support to all individuals engaging with it. The inquiry has been working to finalise the arrangements for how it will receive evidence from witnesses with lived experience of mental health inpatient services in Essex. The inquiry has developed a framework to ensure that evidence from those with lived experience is obtained in a trauma-informed way, which allows each witness to provide their best evidence. A draft version of the inquiry's lived experience framework, along with the associated questionnaire, was sent out to all relevant legal representatives in April, with an invitation to provide observations. All comments then provided by legal representatives were carefully considered and taken into account. Consequently, an updated and final version of the lived experience framework, along with the updated and final version of the questionnaire, was sent out to legal representatives last week and will be published on the inquiry's website. The inquiry will afford those core participants and their legal representatives an extended period of time in which to complete the framework questionnaire. The inquiry will then circulate a proposed timetable for the taking of that evidence once core participant responses have been received. We are grateful to the core participants and their legal representatives for their helpful engagement in the exercise. I'd now like to say a few words about this hearing, which runs from today until Monday the 14th of July. As I set out at the beginning of this statement, over the 5 days of this hearing, the inquiry will focus solely on evidence from bereaved family members. The inquiry has invited these witnesses to give evidence of their recollections and concerns, and we have also invited them to give their current views on what recommendations should be made for change. This week's evidence will therefore comprise, for the most part, of family members' first-hand accounts and observations of what happened to their relatives. Hearing this evidence from families now and in October is crucial. As I have mentioned, Chair, you were clear that you wanted to hear first from the families at the heart of this inquiry. This will ensure that this evidence is the driving force in informing the inquiry's investigations. The inquiry is aware that many families and friends have, through their experiences, sadly become experts in various different areas of mental ill health, care and treatment. It values that knowledge and intends to liaise with families engaging with the inquiry and their representatives in relation to the investigation of systemic issues where relevant in each case. The inquiry will not be seeking comments or analysis from the witnesses on documents that relate to their relatives' care and treatment during the course of this particular hearing, nor will the inquiry be hearing other evidence relating to that care and treatment at this stage. Other evidence will, however, form part of the inquiry's investigations and may form part of later hearings. Over the course of this hearing, Chair, the inquiry will hear oral evidence from 12 bereaved family witnesses. We will hear about the following people who have died. Edward Jackson, known as Ed, who died on the 31st of December 2007, aged just 18. We will hear evidence from his brother, Ben Jackson. Amanda Susan Hitch, known as Mandy. Mandy died on the 12th of February 2022, aged 59. We will hear evidence from Mandy's son, Adam Rowe. Terence Joseph Pym, known as TJ. TJ died on the 26th of August 2016. He was 30. we will hear evidence from TJ's mother, Karen Pym. The person known to the inquiry as W4. He died on the 17th of February 2015 when he was 57 years old. We will hear from W4's sister, Janet Carden. Liam Patrick Brennan, who died 4 days after his 29th birthday on the 14th of August 2012. We will hear evidence about Liam from his father, Patrick Brennan. Pippa Whiteward, who died on the 29th of October 2016 when she was 36. We will hear evidence from Pippa's sister, Lydia Fraser-Ward. Stephen Oxton. Stephen died on the 1st of April 2012 when he was 53. We will hear from his son, Alan Oxton. Frederick Peck, known as Fred. Fred died on the 4th of December 2004 at age 54. We will hear evidence from Fred's daughter, Emma Sorrell. Jeffrey George Toms, known as Jeff. Jeff died on the 14th of May 2015 when he was 88 years old. The inquiry will hear evidence about Jeff from his daughter, Linda Costard. Daniel Fairman, known as Dan. Dan died on the 17th of August 2018. He was 53. We will hear from his sister, Jane Mayer. Susan Spring. Susan died on the 1st of February 2012. She was 54. The inquiry will hear evidence from her daughter, Emma Cracknell. And Richard Harland Elliott. Richard died on the 24th of May 2002 at age 48. We will hear evidence about Richard from his sister, Catherine Peck. From these witnesses, all of whom have set out their recollections, observations, and their views on the need for change with courage and clarity, the inquiry will hear about a number of the key themes it will be examining during the course of its work. Those include, but are by no means limited to, a lack of a clear or settled diagnosis, those with dual diagnoses described as being bounced around between different services with no proper oversight of care and treatment, failures to adequately assess, or in some cases to assess at all, failures to admit or section in the face of clear and clearly reported deterioration and or suicidal intent, a revolving door of repeated admissions and discharges with no apparent improvement in mental health and in many cases a deterioration, failures to ensure appropriate inpatient placement and a lack of availability of beds, particularly in mother and baby units. Ward environments, variously described as a holding pen, cold, sparse, and inhospitable. Physical injuries sustained on the ward without proper explanation. A lack of staff on wards. A lack of psychological or therapeutic treatment on wards. Confusion and general mismanagement of proper checks and observations on patients who were at high risk. Serious failures in record keeping and management including in relation to failures to record properly incidents of harm or injury. Dismissive attitudes amongst staff at all levels and at all stages of treatment, both to patients and to families. A woeful lack of engagement with families, friends, and support networks of patients at all stages and across all aspects of care and treatment. Failures to listen to families or to seek input on patients from those who knew them best. Failures to carry out proper checks to ensure that patients could not access items with which to harm themselves. Systemic failures in relation to ligature points. Concerns in relation to medication, including failures to warn in respect of side effects and signs to look out for in the case of deterioration. Concerns in relation to discharge and inadequate assessments prior to discharge. A failure to engage with families in respect of the discharge decision and process. Poor responses to complaints or concerns raised. Closed, defensive, dismissive, and disrespectful attitudes from the trust and from trust staff towards families following a death. Inadequate and error-ridden investigations and investigation reports. And a lack of support before, during, and after inquests into deaths. As I've said, many families have sadly become experts in some of these areas and are uniquely placed to speak to these important issues in a way that no corporate organisation can. I should also reiterate, as I said in April, that the witness statements provided for this hearing by those witnesses will stand in full as their evidence. I say this as the statements will not be read out in full during the course of the hearing. Rather, the witnesses will be asked careful questions about what they've written. Those witness statements will be published on the inquiry's website once each witness has given their evidence. The copies of the statements that are published will be redacted in line with the inquiry's published approach. There are three main categories where redactions may be applied. Staff names. Staff names, including those of junior staff, will generally be disclosed in the course of the inquiry. Individuals can apply for their names to be withheld, however, in line with relevant law and the inquiry's protocol on restriction orders. Each application for a restriction order will be considered individually by the chair. Some staff may need time to decide whether to apply for anonymity and to seek legal advice. While they are given this time, their names will be restricted temporarily. This ensures fairness. The second category, methods of self-inflicted death or self-harm. Details about specific methods of self-inflicted death or self-harm, as well as other highly distressing content, may be redacted to protect the public from potential harm. The inquiry may also apply redactions where it considers the information is unusual and could instruct others. And the third category, other information which may fall under the inquiry's privacy information protocol. This will be information which is personal in nature and which, Chair, you do not consider relevant and necessary to be made public. This would include details such as someone's address or other personal sensitive information. Moving now to the timetable. The inquiry will sit on Monday to Thursday during this week and again next Monday. For this hearing, we will generally start at 10 and finish by 4. There will be a short break in the morning and in the afternoon in which teas and coffees will be provided free of charge for those who are attending. There will be a 1-hour break for lunch each day, which will usually be from around 1:30 to 2:30 p.m. This is all subject to the need for the inquiry to proceed flexibly and take more breaks or make other arrangements as required to support witnesses. It is not necessary to attend the hearing in person to follow the inquiry's proceedings. Call participants and their lawyers who are not attending in person can watch the hearing live on a secure web link. The hearing is also being live streamed on the Lampard Inquiry YouTube channel for anyone who wishes to follow us remotely. Please note, however, that this will be streamed with a delay of 10 minutes. Moving now to the changing mental health landscape. I have previously referred to the changing mental health landscape against which the work of the inquiry is taking place. Chair, you made reference in your opening to the NHS 10-year health plan for England, which includes proposed measures of relevance to the work of this inquiry. The plan, published last Thursday, includes the suggestion that, and I quote, "The NHS's history is blighted by examples of systemic and avoidable harm." Close quote. It makes specific references to, quote, "neglect and poor care of patients under the care of mental health services, including Essex Inpatient Services, 2000 to 2023, close quote. Reference is made to other suggested examples of systemic and avoidable harm in mental health and other health settings. The plan says that, quote, "the failures that underpin each are consistent: incompetent leadership, toxic culture, rampant blame, workplace bullying, and a failure to learn from mistakes. There is also a fundamental lack of transparency, which means low quality or neglectful care does not come to light quickly, that the response is not fast or decisive enough, and that patient, staff, and public attempts to sound the alarm go unheard. It is time for the NHS to learn." Close quote. The inquiry is considering this and other parts of the plan. Recent cases. Chair, when I delivered the opening statement at the April hearing, I observed how sad the inquiry had been to learn of deaths in mental health settings occurring in 2024 and a death as recently as April 2025. I observed that these further tragic deaths may point to serious and ongoing issues in Essex. The inquiry remains deeply concerned that patients are still dying. We will continue to monitor any recent deaths of mental health inpatients in Essex. We also continue to monitor the inquests that are taking place into the deaths of those who died in the latter part of the period covered by the inquiry's terms of reference. We are aware of a number of inquests having taken place in the past few months in relation to deaths of mental health inpatients in Essex in 2023 and from previous years, following which the coroner has issued a Prevention of Future Deaths report. The recent inquest of Elise Sebastian, who died under the care of EPUT in 2021, gives rise to serious issues that this inquiry is investigating. The coroner has indicated that a Prevention of Future Deaths report will be forthcoming. Other inquests are listed for hearing later this year. In short, the inquiry has noted that recent inquests have explored the same or similar failings and systemic issues with which this inquiry is concerned. It is against these ever-present and growing concerns, Chair, that the inquiry is determined to scrutinise what has taken place in Essex over the relevant period. You have made clear that you will make appropriate findings of fact, ensure accountability, and propose robust recommendations for long-lasting change. We are mindful now, more than ever, Chair, that the landscape into which you will be making those recommendations is a changing one. That brings me to the end of my opening remarks. A written version of this opening statement will shortly be available on the website. Chair, we'll rise now until 12 o'clock, when we will reconvene to hear the evidence from our first witness, Ben Jackson. He will be asked questions by my colleague, Rachel Troop. So until 12 p.m, please.
Chair, there is one brief matter. An announcement's been made to the room, but for the purpose of, for the benefit of those watching more widely, I understand that there's currently a technical issue with the live transcript feature, and that's work is being done to resolve that. A transcript is being kept, but it's just to make those watching more widely aware.
Thank you, Ms. Thank you very much.
I, Ben Jackson, do solemnly, sincerely, truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Can you please state your full name for the record?
Benjamin Charles Jackson.
And you are the brother of Edward Jackson,
That's
known
correct.
as Ed, who died on the 31st of December 2007 when he was 18 years old.
Yes.
When Ed died, he was an inpatient on Maple Ward at Severals Hospital in Colchester.
That's
yes?
correct. Yeah.
You'd like me to refer to you throughout your evidence as Ben, is that right?
Yes, please.
And to your brother as Ed?
Yes, please.
By way of background, the inquiry sent to you some months ago a request for evidence under Rule 9 of the inquiry rules, and in response to that, you have provided the inquiry with a witness statement.
Correct.
Do you have a copy of that in front of you?
I do.
It's 42 pages long, and if you turn to page 42, we can see that it's dated the 27th of May of this year,
Yes.
and that you made a statement of truth and then signed on that same page.
That's correct.
Have you had the opportunity to read through your witness statement recently?
Yes.
And is that document true and accurate to the best of your knowledge and belief?
Yes.
That witness statement, as you know, will stand as your evidence to the inquiry. Ben, you also provided, back in November 2024, a commemorative and impact account about Ed, and that was read for you.
Yes.
The inquiry is extremely grateful to you for that evidence, as well as for your evidence today.
Thank you. I'm grateful to have the opportunity to give it.
Before we begin going through your evidence, I want to make clear, as you tell us on the first page of your witness statement, that you have prepared this witness statement to be as full an account as you can. And it's based on your own recollection of events from the time,
Yes.
as well as impressions that your parents had at the
Yes.
time.
Yes.
It's also based, do I understand correctly, on your consideration of some documents that you had not seen at the time, but you have seen more recently.
Yes, that's correct.
It's right, I think, that Ed was 2 years your younger,
Yes.
and for much of the time, looking at the time period between about the summer of 2005 and the end of 2007, you were away at university.
Summer of 2006.
So you were
That's
away
when
for that last part
Yes.
of the events we're going to go through. You've explained in your witness statement, as you did during your commemorative account, that your own recollections from the time are not full, and that your memories of that period of your life are less clear
Yes.
than they are. Is that right?
Yeah, that is true. It was reassuring to me that the memories that I had upon reviewing documents were often validated.
Yes.
Found that reassuring. So I have confidence in my memories from the time,
Yes.
although they obviously don't cover everything.
No. But you've also, as we've said, reviewed certain reports and documents that you refer to in your witness statement. And I think you told us in your commemorative account in November that actually at the time you understand now that your parents sought to protect you from some of the more distressing details about what was happening for Ed.
Yeah, I think that's the truth of the matter.
Yes. And also that you've experienced what you described in November almost as a sort of a temporal dissociation that may well be trauma related.
Yeah, I think so. And that specifically applies to the period that covers his illness.
Yes.
It doesn't apply to the years after that, and it doesn't apply to the inquest years, I don't think. It was,
Yes.
I think, a stress-related response to him being ill.
Yes. Yes, understood. Ben, you also make very clear, and I think this is important to note at this stage, on the first page of your witness statement, that you are still seeking further documents in relation to what happened to Ed.
Yes, that's correct.
And that in particular you do not have a number of documents relating to the Health and Safety Executive's prosecution of the trust
Yes.
in 2020 and 2021, or medical records.
That's correct.
I think it's the case, is it, that you would have preferred to have prepared your witness statement and be giving your evidence having seen those documents?
Yeah, I think so. I think in terms of being able to do a good job, it would be nice to have the fullest account of the situation at the time, but also I think for my own sense of well-being, the lack of them is a little bit sort of disconcerting
Yes.
at some level.
You understand that during your evidence today, on the basis of your witness statement, what we will be taking from you and what is of immense value, despite those gaps that you feel in your knowledge, are your own recollections and your parents' impressions and what you have to say
Yep.
about the documents that you've seen. Being asked, if you could, when you are speaking, just lean slightly further forward,
No problem.
just because you've got, I think, possibly a little bit difficult to hear you. In any event, you've also made clear that when you are in receipt of further documents and those that you consider centrally important, it's very likely that you'll be submitting further evidence to this inquiry.
That's correct.
Thank you. I'd like to take you through, in summary form, but taking you through some of the most important dates and events, the background to the development of Ed's mental ill health and to his care and treatment. And what I would like you to do, it's a lot of me speaking, I'm afraid, but you must stop me if I make an error or there's something that you want to add.
I understand.
So taking all of these matters from the information you've provided to us in your witness statement, your parents believe, I think, looking back, that it was in the early summer of 2005 that Ed started to show some signs of illness. Is that right?
Yeah, I think that's fair to say. I mean, my own impressions were that I was growing up with a teenage brother who was difficult.
Yes.
But yes, I think at the beginning it was quite hard to separate those two things.
He was
Yes.
about 16.
He was about 16.
Yeah.
Your own recollection is that Ed began to become increasingly unwell in the autumn of 2005. And I think it was at that time, is this right, he had transitioned into a new school for sixth form
That's correct, yes.
and dropped out at October half term.
As far as I remember, yes.
You explain that during that period, so after around about October in 2005, his behaviour began to change.
To the best of my recollection, my memories of him being difficult in a way that I guess I didn't feel like was just growing up with a little brother was pretty coincident with his starting sixth form.
I see.
So that was that time, yeah.
Thank you. You say that during that period, so we're talking about October 2005 up to around about Easter 2006, his behaviour seemed to fluctuate in severity. At times he was quite aggressive.
Yeah, I think so. Again, it's difficult to pinpoint exact times over that 2-year period, but certainly we felt threatened in terms of threats of violence. Ed threatened violence to himself as well as to us.
Yes.
Yeah, I think it would be fair to say that was going on at that time.
Thank you. You go on to explain in your witness statement that at around Easter time in 2006, there came a really marked deterioration and a change in his behaviour. And I don't know if you are following it, but if you want to, in your witness statement, this is on page 4, at paragraph 3.1.
Thank you.
You say, in fact, that your parents described this as a marked deterioration, and you make reference to him being unable to sleep, pacing the house, speaking incoherently and curling up in a fetal position.
Yeah, certainly. I mean, my recollection of his behaviour was that it was a marked change from, the person that he was up until that point.
Yes. At that stage, as I understand it, a CAMS mental health nurse did visit at home.
Yes.
And I think the night after that, Ed, under a delusional belief that your parents were trying to harm him, called police.
I think so, yeah, and then fled the house. I think he ran to a friend's house. I think he ran to a particular person who he felt safe with.
Yes. Thereafter, as I understand it, he was detained by police under Section 136 of the Mental Health Act.
Correct.
And an attempt was made to have him admitted to a local psychiatric unit. But of course, he was a child. He was 17, and they were unable to accommodate him. Is that right?
Yeah, it seems that there wasn't a place for him in Suffolk at that age at the time.
Yes.
On that occasion.
So he spent that night in police custody.
Yeah.
And was seen, we're now on the 16th of April 2006, by a mental health nurse and an approved social worker.
Yes.
And arrangements were made for him to be admitted to Longview, which was an adolescent unit.
Yes, in Essex.
Yes. Looking at paragraph 3.5 of your witness statement, you tell us there about the admission information that you've seen from his admission to Longview. And there's quite a long quote there.
Yes.
Again, reporting an inability to sleep, flight of ideas, racing thoughts, paranoia, anger, and a preoccupation with physical symptoms.
Yeah.
There's also a comment... Sorry, go
no,
ahead.
No, please.
I didn't mean to interrupt you.
No, I was just going to say yes.
There's also a comment here that he speaks of... This is about 4 lines down. He speaks of hearing voices, although I think this is more likely an internal debate rather than true hallucinations.
Yeah, I suppose I don't know.
No.
I don't feel qualified to say what the difference between a hallucination and an internal debate is.
No. At the time, the diagnosis that was reported when he was admitted to Longview, you've set it out at paragraph 3.6, was impression mixed affective disorder or manic episode, either discrete or possibly with the context of an emerging bipolar disorder.
That's right. So I guess that's the first sort of diagnosis that Ed is going to receive.
Yes.
And there will be multiple more, and they will mostly be different.
Yes. Is it right for me to say, just setting matters in context, that at the time of his death, there was no definitive or settled diagnosis?
That's my understanding, based on my recollection of all of the evidence from the inquest.
Yes. You tell us here about a fundamental error that then took place, where on admission to Longview, Ed was needlessly and unjustifiably detained under Section 2 of the Mental Health Act.
That's right. So I believe the social worker involved signed a form that was only there as an emergency measure in the event that he worsened, he could be admitted, presumably
Yes.
like for everyone's safety. But the social worker signed the form and he was then detained under the Act by mistake.
Yes. So I understand that he did formally meet the criteria for detention, but the key is that he had agreed to the admission, and therefore he should have been admitted as a voluntary patient.
And that was the understanding of the two clinicians at the time, that he was not going to be detained.
Yes.
That's right.
Essentially, when your parents complained about that matter later to Suffolk County Council, the explanation given was that it was an error made without thinking.
Yes.
The form was simply signed. You go on to say there that that needless detention or that error was a matter of serious concern to your parents for obvious reasons, because your brother was a child at the time.
Yep.
And you also tell us there that it had a noticeable effect on Ed. What was that, as far as you can remember?
I mean, my recollections of speaking to Ed about like the possibility of having a mental illness at the time was that Ed was really defensive about that.
I see.
It made him angry. He didn't want it. I mean, I suppose it's incredibly frightening to be told that as a child. So, I mean, there was some degree of, maybe stigma is not the right word, but in Ed's mind that's perhaps what it was, and it upset him for sure to be considered as having a mental illness at that time.
Was it the diagnosis or the differing but possible diagnosis, or was it the detention that particularly the fact that he could be detained?
I couldn't honestly tell you what would have been more important to him now. I think my impression is that in general later on we'll go on to hear that he was defensive and about being diagnosed with a mental illness. I think he found it problematic being told that he was unwell, when I think he perhaps believed that he wasn't, and I'm sure that the detention was, not played into exactly those fears that he had. Does that make sense?
It does. So it added to his sense that there was something wrong.
Yes, I think so. Or maybe it was the first time that sense was brought up in him. I couldn't tell you for sure.
Yeah. Thank you.
Thank you. I understand that Ed was discharged from Longview on or about the 14th of June 2006, it is what you tell us, and also that when he was discharged, no discharge summary was prepared. Is that your understanding?
That is my understanding.
You now know, having reviewed some of the documents, that his discharge from that unit followed a meeting, a CPA or care programme approach meeting, for which a number of reports had been prepared.
Yes.
One of those was a medical report and one was a psychological assessment. And the conclusion of both of those reports was that Ed was not suffering from any form of mental illness.
Yes, that's correct. And that conclusion will be criticised later on.
Yes. I mean, we can speak about that a little now. I understand that in particular the psychological assessment came in for criticism when the Serious Untoward Incident Panel reported.
So the basis of the psychological assessment was in part on two psychometric tests. One of them was the Rorschach test, which you might understand as the ink blot test, which I think is Edwardian perhaps in origin, and the other is was a drawing game of the psychologist in question own devising, which I don't think it was in any way validated. I think in the SUI later we will hear that it has quote unquote no psychometric valuation associated with it, or evaluation. So
it was essentially a sort of squiggle line on a. So we had the I don't know how to say it either. I think it's Rorschach ink blot tests. I had to look it up. The pronunciation, I mean. An ink blot test, which is a sort of image test, and what do you see? Yep. And then a drawing game or test that particular psychologist had invented, him or herself devised, that was not in any way externally validated.
That's my belief, yes. And then I think it's worth saying that as a result of the report of no mental illness, although perhaps that was pleasing to Ed, it made it harder for my parents to access care for him in the coming months.
Of course. So on that, I mean, what you go on to say is that after his discharge into the community, there was essentially almost a total lack of support.
Yeah, that's my understanding from reading the documents. My memories from the time are quite unclear.
I understand. I understand that because this conclusion appeared to have been arrived at, that Ed was not suffering from any form of mental illness, as you say, it was even more difficult for your parents to access appropriate support.
I think that's true.
You tell us that they visited the GP several times to try to access help for him.
Yes, I mean, and some of the reasons that they couldn't access help for him was that the GP had their hands tied in terms of they couldn't discuss Ed without Ed consenting to it. I think because he's over 16. And in a way, perhaps that's fair enough, but it was difficult for my parents.
So they advised your parents, GP advised your parents essentially that the request for help had to come from Ed.
I understand that to be the case.
I understand. There was one follow-up appointment from the local CAMS team in Suffolk, and then when Ed essentially disengaged from that, nobody followed up with him.
Nobody followed up. And then, that single follow-up will also be later criticised in the SUI report after his death.
Yes. The finding of the SUI panel, in effect, was that this was not a low-level event where one follow-up appointment was appropriate.
That's correct.
You also tell us that after being discharged into the community from Longview, Ed made the journey to an aunt and uncle of yours in Yorkshire.
That's right.
Long journey.
Yes.
And that whilst he was there, his mental state continued to deteriorate and he displayed out-of-character behaviour, essentially.
Yeah, that's true. And so my memory of that time is, I guess my aunt and uncle hadn't been exposed to Ed subsequent to his onset of illness at that point, so also presumably weren't sure what was happening.
Yes.
But at some point did relate to us that they were now, having met him, much more certain that there was something wrong.
Yes. And I think through a GP, they did manage to access one appointment with a psychiatrist.
That's correct.
But thereafter, essentially, Ed, for the reasons that you've explained to us, disengaged.
Yes.
When Ed returned home, back to your parents' home, which I think was in June 2007.
Yes.
At that stage, as I understand it, your parents did manage to secure a referral to the early intervention in psychosis team in Suffolk.
Yes.
And during that period, so this is June 2007 onwards, there were a number of home visits from social workers and mental health nurses, is that right?
I understand that to be the case, yes.
Were you by then away at university?
Yes, I was.
Yes. Taking matters forward into October 2007, I understand that on the 23rd, your brother was picked up by police at the side of the road.
Yeah, so he would have been at the side of the A1, I think almost certainly heading back to Yorkshire.
I see.
I imagine in an attempt to find safety again, which is something that I think is going to happen to him a lot in the coming months.
Yes. Attempts to flee to find safety.
I imagine that's what was going through his head, yeah.
Yes, I understand. On this occasion, he was picked up near Grantham,
Yeah.
and police have reported that he was so agitated that tranquilizers were required.
Yeah, the records report that. I'm not sure who said it exactly.
Yes. He was taken to Grantham Hospital for a check, and then the intention was for him to be taken to a psychiatric unit.
Yes, yes.
Another error occurred, and in fact he was returned by ambulance to your parents' home.
Which is precisely, I assume, the place that he was trying to escape from, for good or not reason.
Yes. When he arrived home, the GP attended, as did police.
Yep.
And by the 25th of October, so just 2 days later, he was detained under Section 2 of the Mental Health Act, and police took him to Wedgwood House.
Yeah, that's correct. So
Wedgwood House is where?
in Bury St Edmunds in West Suffolk.
Yes. The records show that whilst he was at Wedgwood House, although Ed was ambivalent about taking his medication, he did comply with it.
That's correct.
And that although he denied it, he was found to be, at that stage, psychotic or in psychosis.
Yeah, and then I think this is the first mention of schizophrenia as a possible diagnosis.
Yes. I understand that there had been a mention when Ed was with your aunt and uncle in West Yorkshire. I understand that an approved social worker had made mention then for the first time of possible emerging schizophrenia.
Yeah, that's correct.
And then this is the second time that we see that potential diagnosis coming up, isn't it?
Yes.
You were aware at the time, you tell us, and if you are following it, Ben, I'm looking now at page 10 and paragraph 5.7 of your witness statement.
Okay.
You were aware at the time that there were serious concerns about Ed escaping.
Yeah, for sure. I remember being told that he'd stolen a taxi at some point. And I know now from reviewing the documents that there were multiple absconsion attempts.
Yes. So I think what the records show and what you've learned from them is that he did manage to escape on the 3rd, 9th and 12th of November 2007 from Wedgwood House, and that on each of those 3 occasions he was returned to the unit by police.
Yes, that's correct.
Sorry, remind me, but was he under section now?
He was.
Yes.
On the 6th of November, a decision had been made to maintain Ed's detention. And Chair, that's at paragraph 5.9 on page 10. During that decision, which was at a review tribunal on the 6th of November, and I'm so sorry, I'm looking at paragraph 5.9, quite importantly, it was noted, so here is where we see a description of a possible emerging psychotic illness and reference to schizophrenia. And there's reference to his guarded and suspicious nature.
I mean, I think possibly if you were involved in a set of circumstances where multiple mistakes had been made, you might feel like being guarded and suspicion was a reasonable response to the treatment that he'd had up to that point.
Of course.
So I guess I find that problematic, especially to the extent that that behaviour seems to some extent justified,
Yes.
but contributed to a diagnosis which may well have been correct, which then would have gone on to further upset Ed.
Yes.
So I find that sort of set of circumstances quite difficult to come to terms with.
Yes. In addition to his defensiveness, again, that we might say was perfectly understandable, particularly given his age, around being told that he was mentally ill or a diagnosis of any kind,
Yeah.
which is not at all uncommon.
Yeah.
One of the matters I wanted to note was that during this review tribunal panel, a note was made of him once having told your parents that he might as well not be living,
Mm-hmm.
and reference to knives and other sharp items being found in his bedroom when they were sort of clearing it or tidying it, whatever, for admission, that he had said he had been using to harm himself.
Yeah, so I'm not clear whether or not those rooms were his room at home or his room in hospital. Reading this was the first. I don't know.
No, I'm not sure either. That's a good point.
Um,
In any event, what is key is that we see here a clear notification to staff that he had made reference at some point to self-harm and to suicidal intent.
Yes, that's correct. And this was the first time, reading these documents was the first time that I understood that he might have used knives to self-harm.
Yes. We know from the records that on the 10th of November 2007, Ed was placed on continuous nursing observations, and that was due to his repeated absconsions from the ward.
That's right.
There are also records from that date of him acting more bizarrely and making threats to kill your parents.
Yeah.
And that his administration of antipsychotic and tranquilizer medication was increased at that stage.
That's what I understand.
On the 16th of November, plans were first made to move Ed to a more secure unit.
Yes.
And on the 20th, he was detained under Section 3 of the Mental Health Act.
Yes. I'm not sure presumably that detention was based on the previous absconsions and self-harm, but I'm not certain exactly why that was.
Yes. Most crucial, given the concerns we're going to go on to discuss, the records show that on the 27th of November 2007, Ed was found with a belt around his neck that he had secured to his bedroom door by a knot.
Yes, so this is still in the same facility in Bury St Edmunds in Suffolk.
Yes, so we're still in Wedgwood House. He's
That's
now
right.
detained under Section 3. That event took place on the 27th of November.
Correct.
And he is recorded of having reported to staff that he expressing thoughts of suicide that were especially intrusive when his mood was low.
Yes.
On the 5th of December 2007, he made a further attempt to escape, literally trying to run from the premises and scale a wall. At that time, he is recorded as having made comments to staff, first of all, of wanting to throw himself under a train,
Yeah.
and secondly, asking that his shoelaces be removed from him because he didn't trust himself.
Yeah. So I guess all of those previous paragraphs speak to an increased frequency in absconsion, so he's more at risk. I guess the public are more at risk because he's stealing things. He's been found with a ligature tied around his neck.
Yes.
He's talked about wanting not to be here, and he's expressed some specific plans to an extent, and
Yes.
then he's asked for his shoelaces taken away from him, which I mean it's incredibly sad, but it also speaks to the fact that it may not be that he really wants to die at that point. But there's built up over the course of about 2 months a high frequency of quite extreme events
Yes.
in Suffolk.
Now, my understanding in relation to the 27th of November and how Ed was found and the comments that he made at that time is that your parents were not made aware of that incident. Is that right?
That is my understanding. It's based on reviewing the documents. I don't have exceptional memory of that at the time.
Yes. And as far as you are aware, were your parents made aware at the time of the events of the 5th of December and that attempt to escape from the premises and the comments he made in terms of suicidal intent on that date?
I'm not aware in either direction. I don't know if they did or did not.
I understand. We know that Ed was transferred from Wedgwood House to Maple Ward at Severals Hospital on the 7th of December 2007.
That's right.
I've now moved Ben to page 12 and to paragraph 6.1.
Yes.
That transfer took place under an SLA or service level agreement between the NHS Trust in Suffolk and NEPT, yes?
That's correct.
And I know that you're going to have further comments about that agreement.
Yes, certainly my parents will discuss it, especially in light of information that they received at the inquest.
Indeed, and I think, is it fair for me to say that many of their concerns centred on what due diligence or what checks were carried out in relation to that agreement and the environment at Maple Ward?
Yeah, so I mean the circumstances are that Ed had been referred there because of the behaviour that he exhibited in Bury St Edmunds, where he's about to leave.
Yes.
And of course, his referral there was an attempt to make him more safe.
Yes.
That's presumably what the aim was.
Yes.
But in fact, the exact opposite as we're going to see, is what occurred, and that's really important, and obviously was really important to my parents.
Of course. In fact, what the records show is that the reason for the transfer, or the basis for the transfer to Maple Ward given, were the ongoing risks of absconding, this is at the very bottom of paragraph 6.1, self-harm, and fleeting suicide ideation.
Yeah, that's
so
correct.
those were the recorded reasons for, exactly as you say, moving him to a more secure unit in an attempt to make him more safe. That was the intention.
Yes.
And we're going to come on to talk quite a lot about Maple Ward for obvious reasons, but is this right? I think you make this fairly clear in your witness statement. Your position, Ben, is that it is entirely possible that had Ed not been transferred to that particular ward, he would not have died.
Yeah, I think that's certainly fair to say. I mean, obviously one can't speak of then the years that might have come later, but I mean, I think it's going to be markedly obvious that he was transferred there and 3 weeks later he was dead, and
Yes.
that was due to serious failings. And of course my position is that if he hadn't gone there, he wouldn't be.
Yes. You tell us in your witness statement that your parents, and you're not completely sure for the reasons why, but they were very impressed with the environment at Wedgwood House.
Yeah, I believe that to be the case. Again, that's from reviewing the documents rather than my understanding at the time.
And that, I understand, is in very stark contrast to their impressions and views about Maple Ward at Severals.
Yeah, concerns about the physical environment in terms of it being an old Victorian asylum.
Yes.
Concerns about there being nothing to do for patients there.
Yes.
Perhaps further concerns.
Ben, did your parents ever talk to you directly about what they had seen at Severals? They visited him there.
They visited him there often, yes.
Yes.
I find it really hard to... I don't have a clear memory of them doing that, but I do have a clear sense of knowing what it was like. So it may be that they did, but it also may be that my memory was based on evidence at the inquest.
Right.
I couldn't tell you for sure.
Right. Thank you.
In summary, your parents' views, I think this is right, and it's as you set out, is that neither the environment nor the staff on that ward were fit for purpose.
Yeah, I mean, the staffing issues, I'm not certain how much their opinion of the staffing issues were formed by the inquest material that was received.
Yes.
But certainly that was the opinion that they would reach eventually.
Yes. They described it as a depressing environment, and as you've said, one of the things that they noted was that there was almost nothing for patients to do other than watch television.
Yeah, and so it's notable that Ed was referred there on the 7th of December. On the 8th, my parents visited and brought him a personal CD player.
Yes.
They weren't allowed to give it to him because there was a headphone cable, so that was deemed too risky. And the day after that, staff at Maple Unit returned his belt to him, which I think may have been linked to a change in risk assessment, or a change in level of observations for some reason.
Yes.
The day after he died, they planned, before he died, to be bringing him a PlayStation. So yeah, lack of therapeutic activity.
So that he had something to do.
Exactly.
I understand. As I understand it, what they also discovered was that there were no psychological or occupational therapy services available.
Yeah.
Your parents were told that they couldn't visit in the evening.
Yeah, and that was factually incorrect. It was miscommunication. They apparently were allowed to visit in the evening, but
Yes.
as a result of that, they did not.
Yes.
And then obviously they had limited time.
They were both working,
Yeah.
so they tried to visit in the day if they could and
Yes.
at weekends, but
Yep.
later discovered that they could have been there in the evening. Is that it?
That's correct, but they
Yes.
were informed by a member of ward staff that evening visits weren't permitted.
Yes. Ed's key worker, you have discovered, was on night shifts throughout.
Yeah, yes. I'm not sure completely 100% throughout, but yeah, certainly the majority of the time, to the extent that disciplinary action into that was recommended at the 7-day panel.
Yes.
It was a theme of the inquest. It's the part of the inquest that I remember most clearly, asking whether or not them being in night shifts whilst being a key worker meant that they could fulfil their duties to Ed. It's something that I've talked about in other contexts prior to this inquiry, so I think that's something that's really stayed with me.
Okay.
So the person that was responsible for coordinating his care
Yes.
was not available to him.
Yes. All right. We'll come back to that, I think. The other things that your parents noted that are very important and relate to the matters you've told us about your parents trying to bringing him a music player but not being allowed to give him the earphone cables, so the cable wire, and wanting to bring him a PlayStation. I understand that Ed lost a lot of weight while he was an inpatient on Maple Ward.
Yeah, I think so. To the extent that his trousers were falling down because he
Yes.
was so thin, which was, I think, justification, at least my memory of the inquest, that was verbal justification for the return of his belt.
Yes. I understand that the records seem to show that staff were concerned by the amount of weight that he'd lost, and there was a suggestion that because of his trousers were falling down that other patients were teasing him.
Yeah, and I think he did experience bullying on that ward, and in
Yes.
particular the day of his death, I believe he experienced some sort of bullying.
Yes, on that day there's a record that shows that there was, and this is the 31st of December, so moving forward a few weeks in time, there's a suggestion that there had been an altercation between Ed and a male patient, and a suggestion in the records that that particular male patient had
May have been picking on him.
intimidating Ed and possibly targeting him.
Yeah.
We bear in mind he had just turned 18 in the spring of 2007, yes,
he
and this was
on
an adult unit.
ward, yeah.
When Ed first arrived on Maple Ward, he was placed on level 2 observations, the records show.
Yes.
And as you said, the next day, the 8th of December, your parents were prevented from giving him a portable music player because of the risk presented by the earphone cables.
Correct.
Nonetheless, as you've told us, the next day, the 9th of December, both Ed's belt and his shoelaces were returned to him.
Yes.
We'll come back to this, but the 7-day report found that no risk assessment had been carried out.
Yeah, and there was no written rationale of any kind associated with that decision.
It appeared to have come about just on the basis of a sort of discussion between staff.
A sort of ad hoc discussion, yeah.
And at this time, you still have no clear information about who decided to return those items to your brother or on what basis.
No, that's correct. And obviously I think one of the things that one thinks about is that there are no therapeutic activities available, but you can't have a music player, but hey, you can have your belt back. It just speaks, I think, to a sort of chaotic and not coherent program of care.
Yeah. Yes, or a coherent or consistent approach
Yeah.
to risk,
Yeah.
which is a huge concern of yours that we'll come on to.
Yeah.
On the 9th of December, we know that a NEPT, well, we don't know, it is said that a NEPT risk assessment was completed for Ed.
Yes.
That risk assessment is dated the 9th of December,
That's right.
but I understand, and we will come on to this, that there's some doubt about when that assessment was actually completed.
So that assessment was not included in the electronic care record
Yes.
program care base.
Yes.
It only appeared to anyone post his death.
Yes.
So there is some, I think, and looking into those matters was recommended in the 7-day report. So there's some confusion, and I think
Yes, we'll come to that. I understand that the author of the 7-day report found that it wasn't in the file, it wasn't on the file,
Yep.
asked for it. It was said to be a handwritten note that Ed's key worker said he did have
Yes.
and would be produced.
Yes.
In fact, the original was never produced. A photocopy was provided on the 2nd of January 2008.
I believe that at that point it was asked to be added to his file.
Yes.
I guess on the electronic care.
I understand. In any event, quite crucially, what that risk assessment recorded, if we look at this, please, this is at you and I, if we look at this, this is at page 14 in paragraph 6.8. That risk assessment recorded this, that Ed has not expressed suicidal ideas and no previous known attempts. I'm just going to wait for a moment. So sorry. I'm
Good.
just being reminded of the time.
That's okay.
I told you that wasn't great on time. I'll just finish this section, and then I think as long as you're happy and Chair, you're happy, we'll perhaps take a break then. It's very shortly. I'm going to read that again, it being crucial. That NEPT risk assessment recorded that Ed has not expressed suicidal ideas and no previous known attempts.
Yeah, so that's factually incorrect.
Demonstrably wrong.
Demonstrably, categorically wrong.
Yes. And actually we've been through all of those events that were
Occurred in
notable in and of themselves, but had built up a picture which make that categorically incorrect.
Yeah, and they were over the previous 2 months only,
Yes.
and they were expressed, I understand, in a comprehensive risk assessment by Suffolk,
Yes.
provided to Essex upon his admission
Yes.
to Maple Ward.
So we'll come to this, but my understanding is that on file was a comprehensive 9-page report from Suffolk, but of the 9 staff who were interviewed for the serious untoward incident report, only 2 of them had seen it.
And 5 of them were not aware of any suicidal risk.
Yes. Right. So we'll come on to that. Ben, as long as you're happy, I think this might be a good time for us to break, Chair.
Thank you.
Thank you.
And we'll come back again at 2.
2. Thank you.
Thank you. Thank you.